Article 5 of the Indian Constitution deals with the citizenship of India. It states that at the commencement of this constitution, every person who has his domicile in the territory of India and 1. was born in the territory of India, or 2. either of whose parents was born in the territory of India, or 3. has been ordinarily resident in the territory of India for not less than 5 years immediately preceding such commencement, shall be a citizen of India. This article provides the criteria for determining the citizenship of India at the time when the constitution came into force. It establishes that anyone who was born in India or whose parents were born in India or has been residing in India for at least 5 years at the time of the constitution's commencement is considered a citizen of India. It is important to note that citizenship laws in India have undergone significant changes since the constitution was enacted. In 1986, the Indian Citizenship Act was passed, which provides for the acquisition and termination of citizenship by various means, including birth, descent, registration, naturalization, and renunciation. Article 6 of the Indian Constitution deals with the rights of citizenship for migrants to India from Pakistan. The article lays down the conditions for granting citizenship to those who migrated from Pakistan to India after the partition of the country in 1947. According to Article 6, a person who migrated to India from the territory of Pakistan after March 1, 1947, but before July 19, 1948, and has been residing in India since then, shall be deemed to be a citizen of India. This provision was included in the Constitution to address the issue of large-scale migration that occurred during the partition of India. The provision for granting citizenship to migrants from Pakistan is based on the principle of jus soli, which means that citizenship is determined by the place of birth. However, in this case, the provision also takes into account the time of migration and the period of residence in India. It is important to note that Article 6 only applies to migrants from Pakistan and not from other countries. Additionally, the Citizenship Act of 1955, which was enacted after the Constitution, provides for additional provisions for the acquisition and termination of citizenship. In summary, Article 6 of the Indian Constitution grants citizenship rights to those who migrated from Pakistan to India during a specific period and have been residing in India since then. The provision was included to address the issue of large-scale migration during the partition of India in 1947. Article 7 of the Indian Constitution provides for the citizenship of certain persons who migrated to India from Pakistan after the partition of India in 1947. This article lays down the criteria that such persons must meet to be deemed citizens of India. According to this article, if a person migrated to India from Pakistan between the 19th of July 1948 and the 1st of March 1949, then he or she will be deemed to be a citizen of India if 1. the person, or either of his or her parents or any of his or her grandparents, was born in India as defined in the Government of India Act, 1935, as originally enacted. 2. the person has been ordinarily resident in India since the date of his or her migration. In simpler terms, this means that if a person or his or her parents or grandparents were born in India as defined in the Government of India Act, 1935 and he or she migrated from Pakistan to India between the 19th of July 1948 and the 1st of March 1949 and has been residing in India since then, he or she will be considered a citizen of India. It is important to note that this provision applies only to persons who migrated from Pakistan to India during the specified period and not to persons who have migrated to India from any other country. Additionally, the provision only applies to those persons who meet the eligibility criteria mentioned above. Article 8 of the Indian Constitution deals with the citizenship rights of people who migrated to India from Pakistan before the establishment of the Indian Constitution. It provides that any person who migrated to India from Pakistan on or after March 1, 1947, but before July 19, 1948, and has been residing in India since then, will be deemed a citizen of India. This article applies to people who migrated from what is now Pakistan to India during the partition of the country in 1947. The purpose of this article was to provide citizenship rights to those people who were displaced due to the partition and had made India their permanent home. However, this provision does not apply to persons who were or are declared to be enemies or have been associated with enemies during any war between India and Pakistan. In other words, if a person was involved in any activities against India or was declared an enemy of India, they would not be eligible for citizenship under Article 8. It is important to note that Article 8 was added to the Indian Constitution by the Constitution Amendment Order 1950. This amendment was made to give effect to the Delhi Agreement 1950, which was signed between the governments of India and Pakistan to provide for the protection of minorities in their respective countries. Article 9 of the Indian Constitution is a short and simple provision that relates to the rights of citizenship. It states, persons voluntarily acquiring citizenship of a foreign state are no longer citizens of India. In other words, if an Indian citizen voluntarily acquires citizenship of another country, they automatically lose their Indian citizenship. This provision is in line with the principle of single citizenship, which is enshrined in the Indian Constitution. The principle of single citizenship means that a person can only have one citizenship at a time. Unlike some countries that have dual citizenship or allow their citizens to hold multiple passports, India only recognizes one citizenship per individual. Article 9 is significant because it helps to maintain the unity and integrity of India. It ensures that Indian citizens are fully committed to the country and do not have divided loyalties. It also prevents foreign countries from interfering in Indian politics by influencing the decisions of Indian citizens who hold dual citizenship. It's worth noting that there are some exceptions to Article 9. For example, a person who is a citizen of India by birth or descent may be allowed to acquire the citizenship of another country without losing their Indian citizenship. Similarly, a person who is already a citizen of another country may be eligible for Indian citizenship through naturalization, but they would have to renounce their previous citizenship. In summary, Article 9 of the Indian Constitution is a crucial provision that helps to define the rights and responsibilities of citizenship in India. It ensures that Indian citizens are fully committed to the country and prevents foreign interference in Indian politics. Article 10 of the Indian Constitution provides certain rights to every person who is arrested or detained by the authorities. These rights are aimed at ensuring that a person is not subjected to arbitrary arrest or detention, and that the person is treated fairly and given a speedy trial. The article states that a person who is arrested must be informed of the grounds for their arrest, and must be given the right to consult and be defended by a legal practitioner of their choice. This ensures that the person has access to legal representation and is able to defend themselves effectively. In addition, Article 10 stipulates that a person who is arrested must be brought before the nearest magistrate within 24 hours of their arrest, excluding the time necessary for the journey from the place of arrest to the court. This ensures that a person is not detained for an extended period without being produced before a court. Furthermore, Article 10 guarantees that every person has the right to be tried in a court of law by a competent and impartial tribunal. This ensures that a person is not subjected to arbitrary detention or punishment without due process of law. Overall, Article 10 of the Indian Constitution provides important safeguards for the protection of the rights of persons who are arrested or detained, and ensures that the justice system operates fairly and efficiently. Article 11 of the Indian Constitution grants the power to the Indian Parliament to regulate the rights of citizenship of certain persons who migrated to India from Pakistan. The article specifies that the Parliament may enact laws to determine the acquisition and termination of citizenship, and other related matters for individuals who migrated to India from Pakistan after the 19th of July 1948. The purpose of this article is to deal with the specific circumstances surrounding the migration of people from Pakistan to India during the time of partition in 1947. The article allows the Parliament to make retrospective provisions related to citizenship for these individuals. It is important to note that the article specifies that any such law made by the Parliament regarding citizenship of individuals who migrated from Pakistan to India shall not be deemed void on the grounds that it is inconsistent with the fundamental rights guaranteed under Part 3 of the Indian Constitution. Overall, Article 11 gives the Parliament the power to regulate the citizenship of a specific group of people who migrated from Pakistan to India during a particular time period.